Assalamu alaikum and greetings to all. Welcome to the social distancing discussion arranged by the Association of Muslim Accountants and Lawyers. First, an apology. Due to personal matter arising yesterday, retired Judge Dr. Zak Yaqub tendered his apology. We are indebted to his replacement, Sandy Singh. Secondly, there has justifiably been concern at the male-heavy composition of the advertised panel. The webinar was conceived just 5 days ago. We first approached a female and a Jewish person, both eminent lawyers. Both declined. We then invited more widely on the basis that the first three who accepted would form the panel. The subject is Judges' Code of Conduct in the light of the talk by Chief Justice Mogoeng at the Jerusalem Post webinar. If people want to raise any questions, they can do so on the Q&A tab. The topic is not Christianity, nor Israel, nor politics. It is not about loving or curses. Freedom of speech is a given. It is not even about Mr. Mogoeng. Amal's objective is simply to be educated on whether, in terms of the Judicial Code of Conduct, it is more appropriate for a standing judge to publicly take sides in a political matter and express religious or political beliefs which appear to be an antithesis of the Bill of Rights and the international law obligations of our country. His comments were not spur of the moment, but a crafted, lifelong belief expression. The public cannot suspend disbelief that our Chief Justice is unaware of the war and other crimes of apartheid Israel. In his world, it does not appear to matter. CJ said that he was bound by South African law, yet free to express views in his personal capacity. However, he was advertised to speak and was addressed as the Chief Justice. Zionist propagandists brand any objective criticism of modern-day Israeli crimes as anti-Semitism. CJ Mogoeng disingenuously appears to brand criticism of Israeli actions as cursing Israel. The South African Council of Churches does not agree with him, but religious contestation is immaterial to our discussion. South Africa has trade relations with Israel. Our government supports internationally sanctioned two-state solution recognized by both Israel and Palestinians. Recently, diplomatic relations with Israel have been downgraded. Our CJ criticized government stance, declaring his unconditional, undiluted love for modern-day Israel, making no mention of the rights of Palestinians. Now, our Bill of Rights is based on the foundational values of equality, dignity, and Ubuntu. It guarantees freedom of movement, housing, and basic necessities, all of which are denied to Palestinians. They have Israeli-only apartheid roads. If an illegal settler wishes to travel, then the Palestinian population will have to wait at roadblocks for hours to get to work or hospital. Mothers have given birth at roadblocks. UN has declared Israel guilty of war crimes, and our government and judiciary are obliged to enforce international law. At the time of his appointment, Mogoeng said, God chose him to be CJ. Now he fears the curses of his God. The issue is not about throwing Palestinians under the bus. Tomorrow, it could be foreigners, or females, or gays, or poor, or whoever, This is purely a matter of legal principle. Chief Justice Mogoeng has given what are generally regarded as sound judgments in accordance with our Constitution. But do such public comments erode the confidence in and perception of the judiciary by a litigant? Justice must not only be done, but seem to be done. I suspect that all religious beliefs have certain aspects that do not square with our Constitution. But it matters not what religion, and I make no moral judgment. Is it permissible for a judge to be Dr. Jekyll and Mr. Hyde in commitment to our Constitution? What confidence does a litigant have in judges who openly fear their gods when failing to follow a peculiar belief system? Would it be okay for a judge to deny the Holocaust? Is it okay for a judge to say Blood River and apartheid was godly work? How would such comments be viewed by propagandists masquerading as born-again freedom of speech activists? I'll quote Emeritus Judge Thambapale. A judge should never enter the party political arena and express a partisan political view which amounts to favoring one side or the other, except where a party adopts a policy or view which violates the tenets of the Bill of Rights. Apart from politics of the matter, this is a human rights issue, and a sitting judge, having sworn loyalty to the Constitution, ought not to express a view based on a judge's religious belief or political beliefs, which amounts to the antithesis of those rights, close quotation marks. I can give you an example. A president or member of a club expresses a view repugnant to the constitution of that club. He would, in terms of the rules, be given a hearing to determine whether he brought the club into disrepute and what the sanction ought to be. Amal would like to confine this webinar to how a standing judge in South Africa is expected to conduct herself. And if she does not, then what should the consequences be from a legal standpoint rather than a politically expedient one? Before I let the panel loose on an unsuspecting public, what does the Code of Judicial Conduct state? I'll just read a few articles. 12.1b constrains a judge from becoming involved in political controversy. 13b is breached if a judge fails to recuse herself from a case where there is reasonable suspicion of bias against one of the parties. So it doesn't have to be actual bias, it just has to be a suspicion of bias, a reasonable suspicion. 14.2a precludes a judge from extrajudicial activities that are incompatible with the confidence in the impartiality of judges. I'm going to give each of the panelists 10 minutes, and we're going to have to be strict about that. Munira Osman Haider is an executive member of Amal. She lectures in constitutional law at UKZN. Attorney Munira has an LLM, is currently reading for her doctorate. Her research interests include constitutional law, human rights, and Islamic law. Munira will now introduce our speakers as each of them comes on. Over to you, Munira.
Shukran. Assalamu alaikum, and good evening to all of our attendees and the panelists, and thank you for allowing me this opportunity. It's quite an honor to introduce our guests to all of you tonight. And so our first guest is a homegrown boy, Professor Ziyad Motala, who's currently a professor at the School of Law of Howard University in Washington in the United States of America. Ziyad has also served as honorary professor of law at the University of Western Cape. And like I said, he's homegrown, you know, as we say in South Africa, locally is lekker. So Ziyad is a Durban boy, has been very active in our liberation struggle, even though he's away. And in his student days, I believe he was very, very active through the Black consciousness movement. In terms of his qualifications, he has an LLB, which he obtained from the then University of Natal, and then went on to get a master's and a doctorate from the University in Chicago. He's an authority on international law, constitutional law, and comparative law. And he has delivered many papers and published in these areas widely in the globe. In South Africa, his interest is around our democracy and our newly formed democracy. But his interest here has not been dimmed by his absence. So he's kept his fingers on the beat, so to say. He has co-authored with Cyril Ramaphosa, our current president, the book titled Constitutional Law Analysis and Cases. So it shows that he's still very, very much interested in what goes on in South Africa. He has also authored another book, Constitutional Options for a Democratic South Africa, a Comparative Perspective. And my reason for saying all of this about Professor Ziyad Motala is that when he does speak now, and I'm going to hand over to him, you'll understand why we chose him as a guest for this webinar tonight. Professor Ziyad Motala, over to you.
Munira, thank you very much. It's a pleasure to be on the panel and partake in this discussion. Although one hoped the unfortunate utterances by the Chief Justice did not occur, as it compromises our judiciary, which is such a critical institution and bulwark for protecting our Constitution. Let's start off with the view that the Chief Justice is entitled to his opinion. Yes, he's entitled to his political opinion, but when a judge expresses their opinion in a manner that does not comport with the Constitution and with the Judicial Code, as Aslam pointed out, that is a problem. There are two problems with the Chief Justice's statements. The first is the substance of his statement. It showed a disregard for human rights, which is what he has taken an oath to uphold under the Constitution. And second, as the Chief Justice of the country, he overstepped the line by encroaching on separation of powers and wading into a political matter that the judiciary should not be involved in. Aslam referred us to some pertinent provisions of the Judicial Code, and I think it's perhaps worth recapping on it. And undoubtedly, Article 12(1)(b) is the starting point that provides that a judge must not, unless it is necessary for the discharge of judicial office, become involved in a political controversy or activity. We can add Article 11(f)(2) as well, that instructs a judge not to participate, that tells us a judge may participate in debate in matters pertaining to legal subjects, the judiciary or the administration of justice. Now, Chief Justice Mogoeng's statement clearly did not come within this particular purview. There are a number of other sections with regard to the Judicial Code that we need to bear in mind. The section on the Judicial Code that requires a judge to always act honorably, not only in the discharge of his official duties, the code applies to his behavior even when he or she is not sitting on the bench. Article 6 tells us a judge must always comply with the law of the land. Another article tells us, I think it's Article 7 if I remember, that a judge must always avoid racist, sexist, or otherwise manifest discrimination in violation of equality. And that would apply whether the judge is sitting on the bench or not sitting on the bench. Aslam alluded to Article 13A that says a judge must recuse themselves if there is a reasonably perceived conflict of interest, or Article 13B if there's a reasonable suspicion of bias based on objective facts. When we take a look at the pertinent parts of this Judicial Code, the opinion expressed by the Chief Justice is undoubtedly of a nature that we can characterize as political activity in violation of Article 12 and Article 11 of the Code. The substance is a violation of Article 5 that requires a judge to act honorably, Article 6 that says a judge must comply with the law of the land, and Article 7 that speaks in favor of equality and against racism, saying that he cannot speak against Israel and ignoring all of their abuses because that is what a judge thinks their scripture instructs them, is a violation of equality and also separation between church and state, which I will address in a few seconds. It also goes against a rich body of international human rights law. That statement denigrates an entire group that are victimized because they do not share the religious view of the judge. In other words, what he was saying is because they do not share his views, the Palestinians are less worthy of international human rights protections. Now, let's try to deconstruct Article 12 with regard to the sort of views he's entitled to express. If I can just flesh it out in a couple of minutes. I'll make 3 points in this regard, and they all come back to a judge not being able to act against the Constitution. First, where a judge is defending the role of the judiciary in relation to the Constitution, that is one thing. So assume a court says that this is what equality represents and this is what the right to a fair trial requires, and the judge subsequently gives a public speech on what he or she thinks the state is not doing or should be doing. That is within the right of the judiciary, even though they may be politically criticizing the government. Here, the judge is looking at the Constitution and what he or she thinks are the legal imperatives under the Constitution. That is different from political statements that the judiciary should not be making. Now, there are undoubtedly instances where the legal and political become intertwined, where a judge, even before a matter comes to the court, says government is not doing something that they are required to do, for example, for transformation. And this occurred with regard to Chief Justice Mogoeng in 2013, where he spoke about lack of transformation with regard to the bar and with regard to judicial appointees. Transformation and the realization of equality for all is a constitutional imperative. Where the judge is pushing publicly for greater attainment of constitutional values, this is not political in the absolute sense. It involves an interplay between legal and political, and there are times where it becomes a gray area. Now, defining that gray area is a major jurisprudential inquiry, which is really a subject for another webinar, but we can say emphatically, Chief Justice Mogoeng's statements did not fall within that gray area. When we talk about foreign relations, there's no doubt that is political in nature. Who are South Africa's friends? How the country determines who are its friends, that is a political matter. Comparative practice informs and instructs us that decisions with regard to matters of international relations fall within the domain of the co-equal branches of government, particularly the executive. So we can say emphatically that under the Constitution, it is the prerogative of the executive and the legislature to make determinations in the realm of foreign affairs. So Chief Justice Mogoeng violated separation of powers. The notion that he made these statements in his individual capacity, it's not open to Chief Justice Mogoeng to hide behind that kind of assertion. The code that I had referred to is designed to regulate his conduct, both on and when he's off the bench. He is a Chief Justice. A judge is a judge 365 days a year until the end of their term. They have to behave in terms of the structure of separation of powers, whether they are on the bench or off the bench. And they absolutely have to adhere to judicial ethics with regard to utterances both on and off the bench, as the judicial code spells out with respect to these matters. So the individual capacity argument is extremely misinformed. I mean, as a side, think about it. If the Speaker of Parliament or the President gave a speech and said that they are making an utterance in their private capacity, something saying that they do not believe that women should have equal rights because that's based on the scripture, or a particular religious group is not worthy of human rights protections because they don't subscribe to the same God, but they will abide by the Constitution. That's something that they are rendering in their private capacity. I mean, that would be absurd. It's just crazy to think politically they will get away with that under the guise of having a right to their opinion as private citizens. With regard to the judiciary, this is a particularly special burden that they have to carry because they perform an adjudicative functions. And courts in many jurisdictions have stated emphatically that foreign relations is not within the ambit of the judiciary. And in that regard, I think it's very clear that separation of powers has been violated. The second problem with regard to the Chief Justice's behavior is his use of his religious doctrine as a principle to evaluate the government's behavior. We are a secular and a plural state. No one's religious views should be used as a criterion to judge the legality, propriety, or the wisdom of government's action. This applies particularly to judicial office and certainly to the highest judicial office of the country. Judge L.B. Sachs, for a unanimous court, tells us in the Furi case, it's one thing to acknowledge the important role that religion plays in our public life. It is quite another to use religious doctrine as a source for interpreting the Constitution. He goes on to say, it would be out of order to employ the religious sentiments of some as a guide to the constitutional rights of others. And that was a unanimous judgment.
Ziyad,
yes.
We've got to move on to the next. If you can continue in your summation 5
Okay, so the final point I will make is there are background factors to evaluate what are constitutional under our Bill of Rights. Article 39.1 is very emphatic, international human rights. Law is an operative part of our Constitution. Chief Justice Mogoeng ignored Article 39.1 and international human rights law, which is binding on him with regard to how we view human rights violations in favor of his scriptures. And that is a violation of his judicial duty. My time is up. Thank you very much.
Back to you, Munira.
Thank you. It's now my turn to introduce our next speaker, who is Advocate Johannes Hendrik de Lange. Served as a Deputy Minister of Justice and Constitutional Development, was also a member and served on the National Assembly of Parliament. He has also served on various cabinet committees in crime prevention, security, and international relationships. And very much like our previous speaker, Johnny is also very much a local boy who matriculated in Durban, got his LLB from the University of Cape Town, and he's one of the stalwarts of the United Democratic Front. He's also one of the founding members of NADEL, which is the National Democratic Lawyers Association. And he's the Director of Legal Education Research and Training Project as one of the NADEL committee that exists. He's also a member of the ANC's negotiating team, or was a member, sorry, when the South African Constitution was adopted. He served as a member of the Judicial Services Commission, and he has quite a long resume. He's served on quite a few committees, etc. Chair of the ANC Parliamentary Study Group on Justice and Constitutional Development, member of the Constitutional Assembly, which was a very, very special assembly that dealt with the drafting of our current constitution, etc. So again, you'll see why Advocate de Lange was chosen to address tonight's session. And I'm going to now hand over to Advocate de Lange to deliver his 10 minutes. And please be mindful, Aslam's going to hold you to your 10 minutes very, very carefully. Thank you. Please unmute yourself, Advocate de Lange.
Let me try again. Salam, everyone, and thanks for the invite. And I support everything that Aslam and Ziyad has said, so I don't actually have to speak. But I want to start in an inauspicious manner by saying that, please, I'm speaking my personal capacity and not in any of the capacities I've held in the past. I think it's no exaggeration to say that when the Chief Justice made this statement, I think we South Africans were just completely shocked. And it was a complete and utter surprise where he did it, how he did it, and the manner in which he did it. And I think that is why there was an immediate, spontaneous response of condemnation right across the spectrum of our society. Now, in that situation, you would think that our leader of our judiciary and a leader in our society would think about very carefully how he responds to this matter and how he deals with it. But I have a statement here which is from a Christian group where he allegedly on the 3rd said, I said at that webinar that those that are plotting against me right now, even to kill me, those that will plot to destroy and kill me even in 10 years' time, they are already forgiven. I mean it. Everybody's insulting me. Everybody is lying about me, whether Christian or not, I love you. And goes on then to say there's no need for retraction. Now, I'm just shocked by the statement, by the response. You would think that one would think carefully why people are so angry and why they are raising their condemnations, and then you would put out a statement that tries and addresses those issues. Instead, it's a complete obfuscation and tries to lay the blame at us trying to somehow suppress the religious views of the judge. And it is just highly, highly unsatisfactory that a person that should act as a unifier in our society, as a leader in our society, actually is being utterly divisive and trying to personalize a matter that clearly shouldn't be personalized. Now, I want to now turn to just my reasons personally why I just acted in shock and condemnation when I saw the statement or I heard the statement. And of course, these reasons I give come from various levels and various sources, and I've already some of them been mentioned, but I quickly go through them. I think the first one is of a very personal nature, and it's one that most peace-loving South Africans and even Madiba held, and that is until Palestine has its freedom, we in South Africa can never say that we have our freedom. And to have that kind of freedom we're talking about is what Aslam has raised, and that the international solution of a two-state solution is exactly what has to be implemented. If that doesn't happen, you will always find people like us talking against whatever solutions are suggested. The second one, Ziyad has dealt with quite extensively, and that is the separation of powers. We all know that our constitution has a separation of powers, one that's still being developed, because we're a young democracy, and one that definitely entails that one branch cannot intrude on the executive domain, on the constitutional domain of another. Now, clearly, as Ziyad has shown, there's a clear breach of separation of powers where the Chief Justice expressed himself on foreign policy. I think in his open letter, Ziyad really captured it beautifully for me when he said, not only does the Chief Justice disagree with a policy, which he never should do, but he in fact chooses sides with a foreign power and support their policy against us. In any other world, that's called treason. That's how serious it is. You cannot support the foreign policies of another country against your own country and you want to be the Chief Justice when you take an oath of office that you'll uphold the Constitution. The third reason I give is that the Chief Justice completely whitewashes the Zionist Israeli state and its unleashing of state power over decades on Palestinians, without a single mention in that whole input of his of the daily injustice suffered by Palestinians, including destruction of life and livelihood, the continued annexation of Palestinian land, and the fact that he does not stand up for the right for foreign Palestinian land. And as Ziyad has pointed out, this clearly raises serious doubts of the personal commitment of the Chief Justice to the universality of human rights and to his commitment to international law, especially relating these two countries. The Chief Justice is a leader of society, and it can never be seen that he, as the Chief Justice, is oblivious and insensitive to internationally recorded and acknowledged injustices and wholesale violations of human rights of a people. How can one turn a blind eye to that aspect, even if you don't agree with all of it? But there's clearly an internationally recorded record, which is just absolutely ignored. Fourthly, according to international standard of judicial ethics, as contained in the Bangalore Principles of Judicial Conduct and as embodied in our own judicial conduct, it is very clear that the judges, as in a blatant and deliberate manner, breached the code. And of course, a breach of the code, if you go and look at it, what it means is you can then have disciplinary action taken. And therefore, there is a complaint at the moment before the Judicial Service Commission, which at some stage will be looked at. Fifthly, as Ziyad has also pointed out, this issue brings the whole judiciary into disrepute. Your Chief Justice cannot go around intruding on the domain of other constitutional institutions and then give the embarrassing dismissal, which I read some of in the beginning. The sixth reason I give is that judges are fully entitled to freedom of religion and prayer, which no one has questioned. I have not seen anyone question, by the way. The only person that's questioned is the Chief Justice. No one else has said he doesn't have a freedom of religion. But the tenets of his religion cannot form the basis of his jurisprudence. And in case of a judge, his religion is best practiced in the private sphere of life. Again, one of Ziyad's beautiful comments in the open letter, which will go down in history, is that he has heard of judges that put their hand when they take the oath of office on the scriptures and then swear an oath of allegiance to the Constitution. But in all his wildest dreams, he has never seen an occasion where someone puts their hand, the judge puts their hand on the Constitution and takes an oath to uphold the scriptures. This is something just unheard of in international jurisprudence. That's a beautiful quote, by the way, Ziyad. Seventhly, in high-profile and public controversial entries by a judge into the political domain, makes him fair game as a participant in political contestation and therefore opens him up for criticism and attack by other politicians. And clearly, one does not want that in any society. That your judges enter the political terrain, and then, of course, they are fair play. You can't enter the political terrain, and then say, oh, but I'm a judge, so don't attack me in freedom of my independence and so on. Clearly, that he himself has waived his right where he entered into the... Judges should, when they enter the arena, the political arena, should be careful because dust will be kicked into their eyes in these political skirmishes, and it may just blind them to make sure that they dispense justice. The eighth reason is that judges entering the political arena seriously impair the functionality and efficacy of the judiciary. Take this one as an example. If anyone raises a case that appears in front of the Constitutional Court dealing with Israel, Palestine, or issues of Christianity, the judge has opened himself up now for an application for recusal. He has placed, by putting his views in the public, he has placed himself in a position that people would want to get him off the bench when those cases are heard. Take another example. The Chief Justice has often spoken in public about the land issue in this country. Now, let me firstly say that everything he says, I fully agree with 100%. But we all know that the land issue and the rights of property is going to land before the constitutional courts and probably precipitate a constitutional crisis. Now, what has the judge done? When he comments about the land issue, he has again opened himself up to a recusal application. How can he ever, when he has fully expressed his view on this matter, even as correct as he may be, how can he not expect to want to be recused? And then
conclude, please. Thank you.
Okay, and then of course, the issue that he raises quite correctly is the landlessness of black people in South Africa is one of the terrible indictments and injustice of apartheid. But somehow he does not see that the same applies to Palestinians. What about Palestinians whose land have been taken away and they're being made landless and the whole little country is fragmented into little dots all over the space? Somehow the human rights of Palestinians on the issue of land just does not apply. But even worse, when a Chief Justice is permitted
Lange, I think this
is the last point I'm making, enter the political domain, why is that not equally applicable to all other judges? So what happens when a white supremacist judge starts making racist pronouncements off the bench? What happens when a misogynist judge starts attacking women? What happens when a separatist judge asks for a white only? So if these judges are permitted to enter the political reign in this way, then all of them can raise their freedom to religion, their freedom to speech, their freedom to have an ideology. And that would obviously just create chaos in the country if each one was to do that. I'll jump the rest and I'll wait for someone else to take it further.
Okay, each of the participants will have a further 5 minutes at the end. I think Johnny, Advocate De Lange mentioned that these were his personal views. I want to repeat that. These are his personal views. They in no way represent the views of Amal. And, certainly when he was talking of treason and so on, I think Amal will dissociate themselves. Not that they agree or disagree, but that these are his personal views. Over to you, Munira.
Thank you. And I just want to say that I really enjoyed listening to, not that I didn't enjoy listening to Professor Ziyad Motala, but later. Okay, I have the honorable task again to introduce our next speaker, and she's a colleague of mine. But more than that, Singh, someone who served her articles with our Marhum Solly Lockhart, who has been the president of Amal for a long time. And so she has that history with Amal as well, because everyone who served articles with Solly Lockhart obviously had some hand in Amal and its activities. Sandhya is an admitted attorney of the High Court, and currently she's an academic at the School of Law at the University of KwaZulu-Natal. And she's involved in teaching many different modules, but of importance to us this evening is international law, international criminal law, international humanitarian law, human rights, constitutional law, etc. Although there's much more to the list that she teaches. Currently, Sandy is reading for her PhD, and again, it's in the field of international law. And her areas of research and interest are obviously human rights, international law, criminal procedure, and constitutional law. And she has also published in these areas as well. So again, our next speaker is also somebody who's quite established and experienced and brings a difference to the scene. So Sandy, I'm now going to be handing over to you for your 10-minute presentation. And you can see from previous speakers that Aslam really holds you down to your 10 minutes. So I'm sure you will be able to say all you need to in the 10 minutes.
Thank you so much, Munira. Not as established, I think, as some of the other panelists here, but anyway, thank you for this opportunity. I don't think I'm actually going to go the full 10 minutes because I think Ziyad Motala and Johnny De Lange have actually covered several of the points I was going to raise in any event. So I'm in full agreement with the views that they have expressed. I'd just like to add to what they have actually said. Firstly, I think the biggest issue I have with the statement made by the CJ is that he has basically confused biblical and political Israel. And the timing of the statement is particularly problematic. Israel had announced its intention to annex part of Palestine. Now, I appreciate that this is not a debate about Israel and Palestine, but I think the CJ's comments have to be taken in its proper context. And when we are assessing the propriety or impropriety of his comments, we have to look at it in that particular context. That being the case, it's unfortunate that his comments came at a time when Israel had announced, or I think was just about to announce, I think it had announced its intention to annex part of the territory. So their intention to engage in what is regarded under international law as being unlawful had already been announced. For the Chief Justice of South Africa to now step up and show support for a country that adopts a position of that nature is highly problematic. It's problematic from the perspective of the Judges' Code of Conduct. Now, that code of conduct, which I think has been dealt with sufficiently already, I'm not going to repeat what the other speakers have said. Both that particular code of conduct also points us to two other instruments. Johnny de Lange has pointed to one of them, which is the Bangalore Principles of Judicial Conduct. Now, that is an instrument that was drafted in 2002. But prior to that, in 1985, we had the United Nations Basic Principles on the Independence of the Judiciary. So the Bangalore Principles, essentially, they are intended to establish what standards of ethical conduct judges should be observing. You would imagine that coming from the United Nations, this plays an important role in how countries deal with judges who might have overstepped the mark, as the CJ is alleged to have done in this particular instance. It also assists countries in drafting their codes of conduct for judicial officers. Now, just a few points I want to make about this is that Ziyad Motala has correctly referred to the type of comments that can be made by a judicial officer. And usually that will fall in the realm of legal subjects. It would include the judiciary or even the administration of justice. Now, in this particular instance, none of the comments, well, not on my reading of it anyway, none of the comments that were made by the Chief Justice during the webinar relate to any one of those three topics. They relate to something else. They relate to his religious belief. He's conflated religion and politics, which is quite unfortunate. And more importantly, the big question is, has he become ensnared in a political controversy of any sort? And I don't think we can doubt that that has in fact happened. As I said, the context in which this was made, the timing of these comments relative to Israel's intentions towards Palestine can't be ignored. Everything has context. We can't look at things in isolation because then we are taking them out of the realm of reality. There are two particular points I wanted to raise about the Bangalore Principles of Judicial Conduct. One of the things it does mention under the particular value, it sets out different values. One of the values relates to competence and diligence. And it says that the judicial duties of the judicial officer take precedence over all other activities. It also says that a judge shall keep himself or herself informed about relevant developments of international law. I don't see how the Chief Justice, if he does at any point claim that he was not aware of Israel's intentions towards Palestine and the legality or illegality of that action, I don't think he can claim to have been ignorant of that position simply because he is under a duty in terms of the Bangalore Principles to keep himself appraised of what the developments actually are. But all of this takes us in considering what all this means, we have to come back to that basic right to a fair trial. And that is what it all comes down to. The Chief Justice, as we know, has been seized with a matter involving the South African Board of Jewish Deputies. And the problem with this is that that particular case involves, well, it's a complaint against a particular individual from COSATU who had made certain comments. The matter went to the Equality Court. It then went to the Supreme Court of Appeal. And now it lies with the Constitutional Court. The problem is that the CJ has been hearing the matter. He is now at the point where he needs to hand down his decision. And the big question that arises is, given the nature of his comments, which seem to favor the Israeli position, does it mean that there is a perception of some sort of bias on his part towards one of the parties to the litigation? And of course, the argument would have to be made for that by the litigant who feels offended by his statements. But that is essentially where it is right now. So his conduct, it's not just about how offended we feel. It's not just about the fact that South Africa has taken a particular position with regard to Palestine and that the CJ's comments seem to run contrary to South Africa's position. It goes right to the heart of a case that he is dealing with right now. And one would expect that a judge who is hearing a matter like this will be somewhat circumspect about the comments that he makes in public. The fact is that no matter where the Chief Justice finds himself, he is always bound by the ethical responsibilities that are imposed by his office. The comments he has made now seem to transcend his office. And it's accepted that a judicial officer can never allow that to happen. You don't stop being a judicial officer simply because you are appearing on a webinar that has nothing to do with the judiciary. One other point I'd like to make here is that in the context of the case that he's dealing with, the obvious question that is going to arise should the affected litigant feel this way is whether the Chief Justice ought to be recusing himself. Now, in that context, this is where the right to a fair trial comes in. This is where you are looking for an impartial tribunal. And the judge's code of conduct requires a very high level of impartiality. If he is found to not be impartial in the case that he is currently presiding over, or if the argument is made that there is this very strong perception of bias on his part, given the comments that he's made outside of the court, then may well be an application for his recusal. So I think these are the factors we need to take into account. I think the very strong arguments, either for recusal or against recusal, will probably come into play at some point. I don't see a litigant wanting to step away from that sort of approach. It makes sense for him to raise it precisely because it deals with the use of the word Zionist. It deals with whether the comments by Mr. Masuku from COSATU constituted hate speech or not. There is a whole history behind this. And Israel's approach to Palestine, because the function where he raised these issues had everything to do with Palestine. So this is why I say that when we look at the CJ's comments, we have to give it context. That particular case that he was presiding over happened within a particular context. His comments now also happened within a particular context. Those two cannot be separated, in my view. I think they have to be taken into account. The issue here is not about Palestine. The issue is about his role as the head of the judiciary in South Africa. It's his role as the head who should be impartial, whose comments, wherever they may occur, can never, ever forget. He cannot make comments that deny, that negate the office that he serves in. That has to be given precedence over everything else. Thank you.
Thank you, Advocate Singh. Just to elaborate on the case that you mentioned. It was brought by the South African Human Rights Council on behalf of the South African Jewish Board of Deputies. Maseko is an advocate of sanctions against Israel, and our CJ appeared with his co-chief from the South African Jewish Board of Deputies and vuvuzelas to the world his allegiance to Israel. He denounces sanctions and declares his love for Israel. So, you know, it's much even stronger than what you mentioned. We now go on to the next segment. Each of the panelists will be given 5 minutes for summation. I am going to pose a question to each of them, and if they can just roughly touch on that in addition to what the summation comments will be. Professor Motala, you first. The international community and Israel support an independent state of Palestine. Now, in his interview at the JSC, Advocate Donnan was asked whether he supported an independent state of Palestine side by side with Israel. Our Chief Justice objected to the question regarding this inoffensive human rights question as a highly sensitive political question. Over to you.
Yeah. So I think the question you're raising attests to the fact that the Chief Justice knew that this was undoubtedly a statement that belonged to the political realm. I mean, to the extent that he says it was not political, I think that interview puts to rest that particular issue. And that goes to the question of also intellectual honesty with regard to his views. You know, he prefaced a part of his comments on the notion that Israel has not harmed South Africa. And one needs to go back to his judgment in the SADC case with regard to Zimbabwe, where he delivered the majority judgment saying that you don't have to harm South Africa. The perpetrator doesn't have to even set foot in South Africa, but there's an obligation on the South African state to investigate human rights abuses in Zimbabwe, even though South Africans were not harmed, nor were the perpetrators in South Africa. Now, the reality is Zimbabwe helped South Africa in the War of Liberation, yet he penned a judgment saying that South Africa is obligated to investigate human rights abuses committed in Zimbabwe. In the case of Israel, again, entirely historically inaccurate in terms of Israel's complicity with regard to apartheid, but he adopts the view that they were not culpable in any way, and that is also incorrect. Johnny, and I'd be interested in getting your views with regard to this, because I suspect that you probably were responsible at some stage for the drafting of the legislation. I am of the firm conviction that we need a constitutional amendment that allows the National Assembly to deal with impeachment of judges for misbehavior without going through the JSC. And let me be very emphatic. Impeachment not because Parliament does not like the decision a judge renders. I mean, that is a bright line that should never be crossed. But I'm talking about impeachment with regard to gross misbehavior. We have adopted a law that says it is best that the judiciary deals with judicial complaints within the judicial branch of government. In our experience over the last 15 years, I mean, two things have emerged. One, the process is completely opaque and behind closed doors. One hardly knows what is going on. And the second thing that to me is very troubling, the Judicial Conduct Committee, the tribunal, and the JSC in its entirety have performed terribly with regard to expeditiously dealing with judicial complaints. I think Judge Motala took about a decade, Justice Poswa a very long time, and unfortunately the current process has not worked out too well. The Judge Schloper matter is going on for over a decade, and we are talking about very serious allegations of potential obstruction of justice by the highest judicial officer in the Western Cape. In the intervening period, the allegations of impropriety on his part has only increased and allegations of bad behavior has cascaded, which seriously undermines trust and confidence in the judiciary. I am of the opinion that we need a constitutional amendment that allows for these matters to come before the National Assembly directly. The Parliamentary Portfolio Committee of Justice should investigate allegations of gross misconduct, and Parliament should vote on their recommendations in a timely manner. If there's a recommendation for impeachment, the National Assembly should vote on it in an expeditious manner. And the oversight function on the part of the legislature is part of separation of powers that we find in many constitutional systems. I think that we have surrendered that oversight function to the judiciary, and the judiciary have proved that they cannot adequately manage judicial complaints against their own. I mean, the record over the last decade has been atrocious. On a side, I also find it uncomfortable that Chief Justice Mogoeng's immediate subordinates should be investigating his behavior. I think that Parliament should resume the oversight function. Sandy's point with regard to context, absolutely correct. I mean, unfortunately, we don't have precedent in the South African example, but there's a rich precedent in the comparative perspective that talks about context. And I think if we take a look at that precedent, the context of Chief Justice Mogoeng's statements clearly point in the direction that if he held those views, he ought to have recused himself with regard to the Cossato matter before it was heard. And clearly, he ought to recuse himself at this juncture with regard to the further deliberations with respect to that matter.
You can start concluding.
I will conclude at that juncture.
Okay, thank you very much, Prof. Motala. We're back to Advocate De Lange. The question besides what you're going to deal with, is there's nothing more difficult to open than a closed mind. Surely a hallmark of a judge is to have an open mind. What confidence can a litigant appearing before a zealot with a predetermined view, not prepared to even listen to 50 million people over 10 years? And the second point that I make is that Rome Statute is part of South African law, and we are legally obliged to observe that. And there's been, I think, it goes without saying that Israel has breached international law in a number of instances. Over to you, Johnny De Lange.
Can I just say that I really agree with everything that everyone said. I don't often agree, but it's been one of those issues that is so obvious and so wrong and so egregious that it's easy for people, reasonably minded people, to agree on it. And I think that the problem is that we've got so many problems in this country. For judges to act in the way that they are doing and therefore creating political controversy surrounding their person, we don't need that at the moment. We need stable parts of our government to be able to hold the center, to try and give guidance, to give leadership. And here is a blatant, deliberate attempt. If you look at what platform was chosen, I mean, a webinar with the rabbi in the Bethlehem Post. I mean, you can't choose a more, really put your finger in the middle of a beehive than doing that. It's a blatant move to create division in our society and to be part of divisions. I'm just so shocked. I really am by it. And as Sandy has said, the big thing that we have to remember, forget our personal views about this and our political views about this. But what does this do to people being inspired to be litigants in front of these judges? I mean, That is the one place in society where you should be able to get a fair shake, even in our courts of law. Now, if judges start pronouncing, imagine the next day, a judge gets up and says, well, the Chief Justice is making political statements. I'm now going to make racist statements. I'm a racist. I'm a white supremacist. I'm a misogynist. I'm going to attack women. You know, can you imagine? How do we get people to get respected? And that is why there are these ethical rules that internationally apply and in South Africa that put a limitation on how judges are expected to act. And so all the things you're saying about how does one then make litigants happy? I mean, yeah, you've got where the judges openly sided with certain Jewish interests and so on, sitting in a court case, hearing the case happily, making no declaration that this may be a problem. So, you know, and it gets to what Ziyad was saying. I made a point here, which I didn't get to, is accountability of the judiciary. You know, we created a constitutionally supreme state, and I have no problems with that. And we made the courts as the final arbiter to decide anything in that constitution. So even when government or parliament do things, the third branch of government can every time rule that what they've done is wrong. So it's only in that situation, your judiciary has to be very balanced. They must be very careful that they don't intrude into the areas of others. Otherwise, like the apartheid judiciary, they will lose their legitimacy ultimately. At the moment, there's a strong view in our country where at least most politicians and most reasonable people try to hold the center, try to not attack the judiciary unnecessarily and so on. But if this keeps on going on, you have a problem. So at some stage, we're going to have to look at accountability mechanism. Because at the moment, of course, everyone just said, well, judges are only accountable to the law. I've always tried to work out what does that mean. I mean, if you interpret what the law is and you're accountable to that. So I don't know if what Ziyad is suggesting, but we have to do something. If you look, for example, how many years it took us to convince the judges just to create disciplinary procedures, something that exists everywhere in the world. Disciplinary procedures, they can run themselves, they can get a budget for it. It took us years to get those things through. If you now look at the court cases, not court cases, the cases before the JSC, it is atrocious. A judge drives into a wall. There's a camera, someone with their camera, they take pictures of the judge. Clearly, everyone can see the man was inebriated. It takes a decade for that thing to move through the processes. How do you sit on the bench? You are judging people in their life and their conduct, and you can't run a disciplinary procedure that's finished at least within a year. Look at these problems we're having around Slope and Goliath. That is a serious constitutional problem. A JP and his deputy fall out. This has now turned into a Muslim-Christian thing. So after the statements of the of the Chief Justice. But not only that, the Chief Justice has just gone and taken the complaints from Slope and the complaints from Goliath. He sits there and he decides, I'm going to dismiss the complaints against Goliath and I'm going to get again. Now, I don't know the facts of the case. It may be quite right to do that, but it creates such a bad impression that you as a Chief Justice, instead of handing it on to others to deal with, when you are personally, complaints have become made by you about the two, and you then get involved and you decide that the one side is wrong, right? And the other side is wrong. That leads up the question, of course, of Christians and Muslims on different sides. It is just...
I've got to move on.
So, Ziyad, just to say, on the matter of accountability, something, I don't know what, but we'll have to sit as a country and talk what we're going to do about this problem. It can't go on the way it's going on.
Thank you, Advocate Lange. Advocate Singh, each of the cases sorry, just before I get to that, Johnny, I just hope that this Amal webinar is not accused of being a Muslim or Amal beehive. That's meant to be a joke. Each case depends on its facts, and one cannot make an informed opinion without a thorough analysis. Now, gender activists have accused Judge Mogoeng of having trivialized violence against females by reducing sentences of men convicted of marital rape or rape of minors. Now, as I say, we haven't looked at the case, but nevertheless, this is the perception that people have made these accusations. Now, I think in one of the things, there were comments he made about minors, which the minor not having shown distress at having been raped when she was raped. And that was one of the comments that was criticized by commentators. Now, this is not a religious thing, but nevertheless, one has to look at it, the context. Now, let's say if you look at Deuteronomy 22, mandates the death penalty for a virgin if she does not cry out for help when raped. Now, rightly or wrongly, if somebody believes that this is their belief system, if you look at it in light where the person is now looking and judging a case, Advocate Singh, could a rape victim, rightly or wrongly, objectively believe that such publicly declared obedience to biblical text by a judge may influence the type of punishment received? Okay, then Munira, if you could take over the Q&A session, please, over to you.
Okay, there's quite a few comments, questions, etc. that have been coming through. So I'm going to try and see. We don't have too much of time, like about a few minutes. So the one sort of burning question is, and I think Johnny de Lange has just touched on that, and it seems to be coming through in many of the questions, is where to after this. So what is South Africa going to do post this statement? So that's something that we're going to have to consider. I'm not sure, I see Sandy is back. So Aslam, do you want her to deal with the question you raised? Sandy, do you want to? Aslam was raised.
Yeah, I'm sorry, it just cut off completely. Could you just repeat the question for me?
Okay, the question was that, of course, each case depends on its facts, and we don't know all the facts of the case, and the judge may well have made a right decision, but whether he made a right decision or not, very immaterial. Gender activists have accused Judge Mogoeng of having trivialized violence against females by reducing sentences of men convicted of marital rape or rape of minors. One of the comments made that that particular minor didn't show signs of distress when she had been raped was also criticized. Now, Deuteronomy 22 mandates the death penalty for a virgin if she does not cry out for help when raped. Now, if somebody believed that that was his belief system, is entitled to that, but could a rape victim, rightly or wrongly, objectively believe that publicly declared obedience to a biblical text like this by a judge may influence his decision in assessing what punishment is appropriate?
I think, thanks for the question. I think any party to proceedings of that nature would rightfully be very doubtful about the question of impartiality. I think one would be right to question it if the presiding judge is one who is constantly using religious texts to explain his views. It's not just about what he does in the courtroom, it's about the perceived bias that might exist. I'd just like to read a little, it's just a couple of lines. There was a judgment in 2009 in the case of Dube and others against the state. And in this case, the court said that a judicial officer must not sit in a case where he is aware of the existence of a factor which might reasonably give rise to an apprehension of bias. So it's not necessarily the case that he is biased, but just the apprehension that people might have that he is biased is sufficient. Now, in the kind of situation that you've just described, where you have someone who's been affected by gender-based violence, that person will have the same view of the leanings of the presiding judge as, for example, let's say a litigant who might be homosexual might have if the judge was to say, well, the Bible says that homosexuality is a bad thing. It's exactly the same position. You cannot be assured that you are appearing before an impartial judge and that you are going to get your right to a fair trial fully seen through. It's simply not going to happen. And a litigant would rightly want to seek the judge's recusal in that kind of situation.
Okay, Advocate De Lange, if you could answer Munira's question, I think that might be the last one, and then we'll end up with closure by Zain, but I'll introduce Zain. Advocate De Lange.
You know, I think the problem is we come out of an apartheid past. And during apartheid, the judiciary was there to be part of this apartheid state apparatus to make sure that what apartheid wanted to achieve was achieved. And so we never created traditions around how we interact with the judiciary, what we expect from the judiciary. So when we came into government, we had to we had to create disciplinary procedures for judges. It didn't exist. We had to create an education institution for them, etc. So all the things that are natural in other democracies and developed over time, we've never had them. And so so that is why, you know, someone like the Chief Justice will often go and talk about things. And when he talks about things that we're happy about, so he talks about the land issue, then all of us will keep quiet. We don't say anything because we think, okay, no. What he's saying now is at least I can accept that. But of course, that creates other repercussions it has, no matter how right he is in what he's saying. So what I think of the way forward is we have to start thinking, and we have to do this in a non-confrontational way. What are the kind of traditions that we want to see and see our judges? Do we want them to drag out disciplinary matters the way they, because if they do, then we must give it to people that can do it if they can't do it. If they're going to sit for 10 years to hear an ordinary drunken driving case, you know, it's just unacceptable. Do you know the other problem is that all the legal costs from all these court cases that they drag out the judge, all that it comes from the taxpayer. They do not pay a single cent towards those costs. So I think that's the one thing. I think the other thing that Ziyad has raised about looking at accountability mechanisms for the, and here we mustn't be misunderstood. We're not talking about holding people accountable where they make judgments on the bench and so on. They must be totally independent to do that. We're really talking in the broader sense, in the administrative sense, on the political. Then we have to start looking at the possibility of accountability mechanisms that are accepted within society.
Thank you, Advocate De Lange. We're now going to have Zain Fakhruddin, Senior Attorney and Vice Chair of Amal, who will close the session for us.
Thank you, Aslam. Assalamu alaikum. Bismillahir Rahmanir Rahim. Wassalatu wassalamu ala Rasulillah. Rabbi shrah li sadri wa yassir li amri wahlul 'uqdatan min lisani yafqahu qawli. Ziyad, nice to see you after so long. It's nice to, it'll be good if we meet in person. And Johnny, you really, I think I'm going to vote for you if you stand for elections again. From my side, I've been given the pleasant task of thanking everyone. Firstly, I want to thank the three panelists, Professor Ziyad, Motala. Listening to you, this amazed me. Alhamdulillah, your knowledge of international law and South African law. I was trying to figure out whether I'm an attorney in South Africa or whether you're an attorney. You know more cases about us in South Africa and you based in Washington. But really, you amazed me. And we want to thank you from Amal and all the people who've been listening in, the participants, etc., the panelists. I think the others, I'm pretty certain you've amazed Johnny and Sandy. But thank you so much, Ziyad, for participating in this panel discussion on this webinar. I think your valuable contributions on important legal arguments you've raised, insights into the discussion and the discourse and the topic that Aslam started with, was no doubt, I think, in my mind, must be well received by the virtual audience we have all over. I'm almost certain that I heard that there are participants or there are people listening in from different parts of the world, Australia and United States. I think Johnny Lange, Amal extends its heartfelt appreciation to you. You are very bold, I must say. I like it. You definitely don't sound like a politician. You're too honest and straight. Well, I'm not generalizing about South Africa. I'm just speaking about the world. But I think you're direct. You're to the point. I think you've informed us how you think, how you perceive things, and how you see it. I think you made some very bold statements, and I see Aslam very quickly distanced Amal from those statements. But I think you said what you wanted to say, and I think we respect you for that. And thank you so much, Sandy. Thank you for your participation, Advocate Sandy Singh. Munira invited you, and you immediately accepted. We appreciate it. I think you made statements. You confirmed some of the things that Ziyad Motala mentioned. I picked up a point. You spoke on the Bangalore principles. I think it may be the need for another webinar. There's so many points that Ziyad raised and even Sandy and Johnny raised. I think Aslam might. There may be a need of a follow-up webinar. I think just to go into the Bangalore principles itself might take you 10, 15 minutes. But definitely, we appreciate your participating in this panel discussion, and we hope you accept the next one. A big shout and thank you to all the participants and all over who've accepted the invitation to join this webinar. Thank you so much. Well, as far as our ever-present Aslam Mayat, his sterling efforts presenting and chairing webinars, looks like he's mastered it now. There's no doubt. I mean, you look at his sassy outfit, slick outfit, not sassy, slick outfit, suit and tie on a 7:30 or 8:30 in the night.
It's not as cold as where Johnny is.
Yes. But thank you so much, Aslam. Excellent. And a warm round of webinar applause to Munira for her introducing the panelists. Munira, as was introduced, is a senior member of the Amal, and we enamored to have her within our ranks. And to all the organizers of this webinar, a big thank you. AC, our PA Farzana, thank you so much. You've worked many days over this for as far as the preparation was concerned. But Mayat, you drove this entire thing. Jazakallah, and thank you so much for that. I think while we're at it very quickly, in 2 minutes, we ran out of time, so I'm going to round up as quickly as we can. I think most of us by now must have heard of Amal. It's the Association of Muslim Accountants and Lawyers of South Africa. It was established in 1984. It's a non-profit organization. I was telling Zak Yaqub on the phone, we are non-sexist. We are open to all, regardless of race, color, creed, or religion. Forget the name, but we're open to everyone. We have speakers, panelists, Muslim, non-Muslim, Christian, Jews. We've had them in the past and we'll continue to have them. But Amal brings together individuals involved in law, accounting, and commerce, professionally and academically, with a view of fostering the spirit of brotherhood, research, and cooperation. In so doing, Amal liaises and interacts with, I thought just some quick background and some PR work for the organization. It'll be greatly appreciated of those who participated. Perhaps get onto our website and please press the join button, join us and become a member. A nominal fee of $100 a year. In dollars, I think it's less under $5, and in pounds, I don't know what it is, but it's a ridiculous amount. But just in concluding, on a little difficult note, a stalwart of our organization, Ahmed Solwa, passed away a few days ago. Really, we ask all of you, he succumbed to COVID-19 over the weekend. We pray that Almighty bless him and all those who have passed on, and Almighty shower his choicest blessings on him and all others who have passed on also. Enver Mullah, our senior EXCO member and past chairman, is still ill in hospital. Members of our committee are keeping in contact with the family and checking on his health. But we ask each and every one of you to pray for him also, that Almighty grant ease and a speedy recovery to Mr. Mullah, and also make it easy for his family, Mrs. Mullah and others who are waiting for him. And we also pray for all those who are sick in the world. Almighty heal them as quickly as we can. And finally, I need not elaborate on the current pandemic that has crippled the four corners of the world. Let us all join in prayer and seek from the Almighty His divine intervention for deliverance from the pandemic, the alleviation of humanity's suffering globally, and for the restoration of a sense of familiarity and normality to life as we have come to know. May we return there to a world and a people unified by our common experience in these trying and unprecedented times. I ask all of you to put your hands together and pray for all those who are unwell and recover them as quickly as they can and return them to their families. Thank you so much. Thank you, panelists. Thank you, Ziyad, Johnny. Really, it was great listening to you and Sandy and Ziyad. I was just so amazed. I started making notes of some of the things you said, and I'm hoping that I'll share these notes to some of our colleagues and friends who couldn't make it. But well done, it was brilliant. And Aslam, as usual, you're a master of ceremony. You've become a master. Thank you so much. We'll close Wal Asr. It's a little prayer where Almighty speaks about time, and we'll just read it. Bismillahir Rahmanir Rahim. Wal Asr. Innal insana lafi khusr. إلا الذين آمنوا وعملوا الصالحات وتواصوا بالحق وتواصوا بالصبر. Thank you so much. God bless. Take care.